My name is Bill Alford. I'm a faculty member here at the law school, which has been a joy and privilege. So today we have for you what I think will be a very exciting panel. We will look at the meaning of sovereignty and the challenges there too, and the opportunities that then unfold and how to create better forms of global engagement and governance. We will look at human rights issues, but not exclusively so. We'll also consider many other dimensions of these challenges. So over the next 90 minutes, I think I can assure you we will have a very stimulating time. I'm incredibly fortunate to be joined in moderating this panel with Anne-Marie Slaughter, who I taught with some years ago. It was always a joy to teach with her. Anne-Marie was a faculty member here at Harvard Law School, Dean of the Woodrow Wilson School at Princeton, Director of Policy Planning for the U.S. State Department, and now head of the New America Foundation. And she has written a wonderful book called The Chessboard and the Web that addresses some of the issues that we'll be looking at today in terms of governance. And happily, we have a great panel, 9 experts drawn from 5 continents, with a range of relevant experience and different perspectives, but all united by having studied here in one form or capacity or another at Harvard Law School. It just shows you the breadth of the law school and the excitement of being here. We do have students this year from 76 different countries. So a word on our format. We'll have approximately an hour of give and take in the panel. I will lead the first part. Professor Slaughter will lead the second part. We say, I look to the past, she looks to the future, being younger and more creative. And then the third part, we'll try to think about some of the implications of this. Professor Okediji, please join us. Yes, some of the implications for the future of the issues we'll be describing today. After that, we want to have at least a half hour for those of you in the audience to ask your questions of our panelists. So let's get started. So our I think everyone is described in the programs. I hope you have the program. Maybe when we turn to the first questions, we'll quickly identify our panelists in the interest of time. So we'll start with Kern Lennartz, who is a Harvard Law School graduate and president of the European Court of Justice, to give us a quick refresher on sovereignty and its historical foundation. So, Kern, would you be kind enough perhaps to say a few words to get us started about the history and underlying rationale originally for the idea of state sovereignty as a way of constructing global order?
Well, yes, thank you, Bill. It's with pleasure that I shall do so. In fact, the present order, international order, is often designated as the Westphalian model of the nation-state sovereignty. In fact, the concept goes back, as you may recall, to the peace treaty of 1648, the Peace of Westphalia, which put an end to the 30-year war in Europe. And in fact, the idea which had more or less governed the world order until then in Europe was that you had a cohesive, medieval cohesive Europe united under the Christendom, and that would more or less keep a balance between all the entities. But as we know, that fell apart when different factions of Christendom started fighting with each other. And the idea is that the modern states and states understood as a nation should really emerge and consolidate themselves as the pillars, dealing and wheeling with one another in an orderly way. Now, this Peace of Westphalia has consecrated 2 principles which can be found in Article 2 of the UN Charter. And that is, first of all, that every state is seen as the ultimate sovereign on its territory. No one else may intervene in the domestic affairs of a state other than that state itself. That's the first principle. The second principle is that all states, so understood, are equal to one another. And that is why you find in the UN Charter the principle of the sovereign equality of all the members of the United Nations. And in the same article, paragraph 7, it is then said indeed that nothing in the present charter shall authorize the United Nations to intervene in matters which are essentially within the domestic jurisdiction of any state, or shall require the members to submit such matters to settlement under the present charter. That is, of course, without prejudice to chapter 7, that is the peacekeeping chapter. Now, in Europe, we're almost 400 years further than 1648. That whole model is a paradigm in the process of unraveling. And the most brilliant example of that is the European Union. Admittedly, there is still the equality of all the member states, all 28, maybe soon 27, member states of the EU are equal before union law. As they say in French, il ne manquerait plus que ça. That's the most normal thing in an order. However, this is a qualitative equality. That is an equal commitment to democracy, the rule of law, and human rights protection. And it's defined as a qualitative equality, which is already something different than what you have nakedly in the UN Charter. And second, the EU does nothing else than constantly interfering in the domestic affairs of the member states. It's meant to do that. Even to the point, and I say this for you as audience, that we have the opposite line of case law to New York versus United States, where here it is thought that the federal government cannot commandeer the states, because that would be contrary to the autonomy of the states. That is exactly now the process in Europe, where we have all sorts of EU legislation which is meant to modify the course of action of the domestic political process of the member states. And it works. So the Westphalian model of nation states is still there, but it is heavily amended towards a networking structure inside the European Union.
Thank you, Kieran. Maybe I might turn to Professor Anaim from Emory University, or Professor Helena Alvear, former Dean of the University de los Andes, to maybe inform us about some of the challenges historically, even before the modern era, the contemporary era, challenges to this idea, this Westphalian idea of state sovereignty.
I think the Westphalian sovereignty model is just simply a Eurocentric notion that existed in prior civilizations across the world. I mean, there is a Chinocentric civilization attitude to political formation and organization. There is the Islamic so-called seer, which is the field of law and experience. But each of those was either Chinocentric or Islamocentric, and we have the European-centric. I think at this point we are in a position where we can step back from just simply retooling and recycling the concept of sovereignty in that European-centric notion into human sovereignty. That is, I would like to propose the sovereignty of the human subject, of the human person. That is really what's at issue, because abstract entities are incapable of holding rights or exercising sovereignty. It is people who do. So let's call it what it is. And when we focus on the sovereignty of persons, then I think we can shift the paradigm altogether in terms of what are the priorities, how to frame the questions, and so on.
Thank you, Abdul. And Helena?
Yes, I actually wasn't going to talk that much about the historical aspect, but more of the understanding of sovereignty not as an on or off. So either in Latin America, there have been lots of discussions about the fact that sovereignty can be argued in certain circumstances or relinquished in certain circumstances. And I was actually thinking more of a contemporary example, which is the peace negotiations that have happened historically in Colombia, where at some periods there was an idea of Colombian sovereignty to advance in the negotiations, and more recent, and that has been argued at certain times as essential to the negotiations. And other political actors within a same country are saying it's not an issue of sovereignty, it's an issue in which we have to relinquish sovereignty in order to apply, for example, human rights treaties or the jurisdiction of the ICC. So that's.
So thank you. So even historically, we see there are some robust challenges of the three different types mentioned to the idea of sovereignty. Let's jump ahead and look at some of the other forces in the world today that really are eroding traditional ideas of sovereignty. We've already heard of a few. Eroding, but also creating opportunities at the same time. I mean, like it or not, it's like King Canute trying to hold back the tides. Sovereignty is being eroded, chipped away at, reformed, modified, whatever verb one wants to use on a constant basis. How about to turn to this side of the panel in the area of trade or in the area of technology or idea transfer? How do we see sovereignty being chipped away? Professor Sung-Hwa Chang of Seoul National University.
Thank you. Maybe I may be seen as an alien to this panel because my focus will be on economic side, and maybe while others are not. Let me just take an example of how the traditional concept or notion of sovereignty is being challenged in the international context, especially international economic context. All the multilateral or regional trading regimes presuppose that each sovereignty is expected to pursue its goal of protecting or promoting its national interest. But what I mean by national here in economic context means a national enterprises. But how can you define the nationality of enterprises in its economic reality? Let's take an example of Apple or Microsoft or some other.
Facebook we have with us.
Yes,
and
indeed.
We'll hear from
yes, indeed.
Head of Global Policy in a moment.
And let me give you one concrete example of how this traditional notion got really challenged in the international dispute settlement for trade-related matters. Last year, U.S. actually bring a lawsuit against South Korea for South Korean government's subsidies for Samsung electronics. But the panel, as well as the appellate body of the WTO, as a dispute settlement body, they found the existence of subsidies. But for the purpose of calculating the margin of the rate of countervailing duties, the denominator should be defined. And U.S. allegation was surely the denominator must be domestic production within South Korea. That just takes maybe less than 20% of the whole world production for Samsung electronics. But panel as well as the appellate body correctly and wisely found that the denominator should be the world production. Then the resulting sum was not able to pass the de minimis rate because the world, some subsidy given by Korean government and taken by Samsung Electronics got spread over the whole world production. Then the traditional subsidy disciplines under the WTO agreement got almost meaningless because they cannot capture this kind of subsidies, which were perceived as national subsidies, but in reality, it became a subsidy to the worldwide production chains of Samsung Electronics. So that is one example of how the traditional concept of sovereignty got challenged in international trade context. And I have some other stories, but let me reserve it for the further.
Thank you. Professor Chung was a member of the appellate body of WTO. And Monica Bicker is the head of policy, global policy for Facebook. And we're curious to hear from that end how this looks.
Sure. I thought the notion of the increasing sovereignty of the person is an interesting one because, in a world where we have social media communications options where people really aren't bound by borders. They are to some extent, and we can talk about that, but largely this is an area for borderless communication. There's a lot more room for determining what you want your world to be and how you want that world to function. And we see that at a lot of different levels, including a couple examples that came to mind as my colleagues here were speaking. We see, for instance, in Iceland, there is a network of neighborhood groups that exist, and people join these groups when they move into a neighborhood, and they would do that before they would register at the post office for a new address. That is a more real representation of where they want to be governed and how they want to govern themselves than the traditional notions that we would have. We also see the ways that people are, whether it's through business development or through developing speech norms. You live in a world where in your daily life in your country, speech is criminalized and you don't have access to certain information in the press because speech is criminalized. But you can go online, and that sort of transcends whatever rules your sovereign state has put in place for speech. So there is some erosion there. At the same time, this interplay between, and I'm thinking specifically about Facebook, but this is something that tech companies confront in different ways. How do we interact with governments? Facebook is a U.S. company, but of the 2 billion people who are using Facebook regularly, more than 85% of them are outside the United States. So that means that we have to think about what German law says about how we should be protecting people's data and what sort of speech is acceptable. We have to think about that in countries like Turkey, where they will block the service. They'll block it entirely. If there's speech that is illegal that rises to a certain level where they think it's worth just shutting down speech in their country. So to this extent, the traditional states still have a lot of the power. And what we see now is these, and we're going to talk about this later, but what we see now is this interplay between these emerging networks that have some power and how they have to play and exist with the traditional states.
Thank you. Speaking of traditional states, our next panelist, Ray Mabus, class of 75 at Harvard Law School, was Secretary of Navy in the Obama administration for 8 years, and prior to that an ambassador and governor. Secretary Mabus, how does this look from your vantage point as we see sovereignty being challenged and also new opportunities as well?
Well, I think it's not a one or the other. And I think what you're beginning to see is how these two things, the interaction of the normal definition of sovereignty and these new webs that are springing up. And there's a paradox in that sometimes and I would argue most of the time, by joining larger multinational organizations, you enhance your own sovereignty. An example is UN Law of the Sea, UNCLOS.
UNCLOS, yeah.
The United States in the 80s, when UNCLOS was negotiated, refused to ratify because of certain concerns about our sovereignty. Now, all those concerns were met, every last one of them. But we are still almost the only nation on earth, certainly the only large trading nation, industrial nation, that has done that. Because of that, we have lost sovereignty. We don't have a seat at the table in terms of disputes about law of the sea, South China Sea, for example, or the Arctic. We are on the outside looking in. We don't have a forum to do that. And I would argue that erodes our national sovereignty as a result. A second example that that I did at Navy was in the Gulf of Guinea. 19 countries surround the Gulf of Guinea. They're facing an enormous array of challenges. Piracy is on the upswing. Transnational crime is on the upswing. Poaching is increasing to fund terror or to fund civil wars. You're seeing trafficking, human arms, drugs on the increase. You're seeing terror move from east to west. I was perfectly happy with nobody hearing me. I seem much smarter if you can only see my lips move. But and things like cyber attacks and cybercrime. Individually, not one of those nations had the capability or the capacity to meet these crises. But put together, with sharing intelligence, put together sharing information, they could, and put together in larger organizations, they could meet a lot of these challenges. So in one sense, they were giving up some sovereignty to share information. But in another sense, what that meant was a pirate couldn't just commit an act of piracy in Togo's waters and by simply passing across an invisible line at sea, escape. And so I would argue that their sovereignty increased because they could better protect the rule of law, they could better protect their citizens, they could better react to a lot of these networks that are transnational, that don't respect lines or borders. And so I think that the relationship is one that's evolving, that it's not either or, and sometimes it's counterintuitive that by giving up some sovereignty for the EU, I mean, I think Brexit, for example, is going to hurt Great Britain's sovereignty, and not the other way.
Thank you. And speaking of sovereignty and the South China Sea, we're fortunate to have Dr. C.V. Chun, SJD graduate since 1972, join us. He was a principal figure in the initial outreach between Taiwan and People's Republic of China. And indeed, traditional ideas of sovereignty also are put into play very much by the situation of Taiwan.
So I need this, right?
Yes.
All right. When you speak to the through the microphone, I was next to you. I heard you say very loud, and I'm very impressed. Thank you, Bill, and very pleased to be back. After when I left, it was 1972, so 45 years. Good to be back. And yesterday I was at the IIS, International Legal Studies, looking on the photo on the wall. I saw photos of, among others, Professor Louis B. Zhong, Professor of UN Law, Professor Baxter, International Law, Abraham Chase, International Law, and for Marin, Transnational Law. And ever since then, I've been back in Taiwan. I've been teaching and practicing, and among others, doing pro bono work like Red Cross. And I enjoy teaching. As a matter of fact, when of the last 10 or some years, I've been asking my student at the class a question. The first question I ask them is, which of the two you think is more important? What are these two? One is sovereign nation, that is 国家. The other being good governance. I asked the student which one you think is more important. The student actually puzzled and then looked at me without knowing how really to answer a good question. I know why they hesitate, because students at Taiwan, even Taiwan is a full-blown democratization country. I say country, quote unquote, a part of China, as much as mainland China is part of China. But students pause because to them, the obvious answer is, of course, sovereign nation is more important than the other term, which is not very familiar at all, good governance. We'll talk about 制度, system. What kind of system you have? Like in the United States, I know for the people, by the people, of the people, for example. Student paused simply has something to do with the fact that I was very happy when I received invitation from Bill talking about sovereign and rights interplayed, and he alluded me and perhaps you all to a treaty which I probably didn't even really put much attention at, Treaty of Westphalia. Yeah. A treaty was signed about 400 years ago, and the law school celebrating its 200 years sort of a birthdays, and the UN celebrate its 70 years birthdays, and for me, celebrating just over 73 years old, when I was 70 years old, I was trying first time riding the unicycle. I say all this, what does this have anything to do with sovereignty? Of course, at my age, when I studied in the university in Taiwan, that was in the 60s, Taiwan was still under martial law. Taiwan, as you know, since 1949, Chiang Kai-shek, the chairman of the nationalist government or nationalist party, was defeated by Mao Zedong, the chair of the Communist Party, and led the sort of like 2 million sort of Chinese from mainland into Taiwan. And my father was one of them, and I and my mother, my brother, with my father, back to Taiwan. Ever since then, I've been raised in Taiwan. I spent only 4 years, 3 years, Susie, 3 years at Harvard, yes, doing my LM and SJD. I just want to get back to sovereignty. Sovereignty was so dear to me when I was in Taiwan from 49 to 87, during which Taiwan was under martial law because there was a communist threat or threat from communists across the street. And ever since 1987, the late Jiang Jingguo, the son of Chiang Kai-shek, lifted martial sort of a law decree, and Taiwan becoming much more freedom. So democracy was possible, and now in sort of its full sort of a sort of scale. And so to me, sovereignty was really part of the blood. But being studied at Harvard and being a citizen sort of raised up in Taiwan all my life, but ever since 1987, as I say, martial law was no longer there. Sovereign right was not so much important, not to mention the fact that we are in the era of digital era. You talk about Facebook, et cetera. And so the student actually answering my question, I say to them, yes, good governance is more important than sovereign state if you do not have a choice. That is, if you have to make a choice, which one is more important? Good governance than your mother state, if that has to be a decision. Thank you.
Thank you very much. Let us turn to my newest colleague, Professor Ruth Okediji. Ruth is a world-famous expert on intellectual property. So, Ruth, from your vantage point, what do you think of this mix, this interplay?
Thank you so much, and I'm going to say from the offset that if I say anything you disagree with, Professor Slaughter and Professor Alford are to blame. They were both my professors, so anything I know about sovereignty, I learned from them. I think that in conversation, especially amongst international lawyers, there is often a tendency to conflate sovereignty with the notion of the political state with the idea, what I would call autonomy. That sovereignty does not always mean that the powers that be, in fact, get to operate without constraint. And so I've always thought of this divide between the Westphalian adherents and those who are less comfortable with the traditional notions of sovereignty as one that is perhaps simplified in part because sovereignty has always been a shared sovereignty. It's always been an overlapping sovereignty. And in some ways, it's always been a shifting sovereignty. And so the concept of sovereignty, I think, still holds a lot of salience in relation to other powers. And so, as Monica suggests, when you are a corporate entity, no matter how large your cash holdings are, the political constraints of a territory still matter. And there, the political power, the de facto political power of the state, remains absolutely vital for Facebook or Apple or Google. In my field of intellectual property, when Samsung and Apple were in a multi-jurisdictional battle over the patent for the iPhone, 30-something countries and their respective patent laws, despite the notion of harmonization, still had to come around a table and figure out what does this patent mean in each jurisdiction. This is also true, for example, in the European Union, which has the European Patent Office, which is not an official organ of the European Union, but nonetheless has overlapping membership between EU member states and non-EU member states. And even there, lawyers still have to understand, well, what's Germany's law? What's Lithuania's law? Right? What does this mean? What does this claim mean within the particular territory of a nation state? So in many ways, I think that the Westphalian concept of an entity with a border that governs a group or a collective remains in some ways more real today than ever before. I think it's under strain. I think it's under challenge. I think there are places in which it has less power, but those are spaces that it has always had less power, even under international law, because with regard to citizens in a flourishing democracy, sovereignty is not what we think about. It's accountability, it's democracy. So I think for as long as there are territories that divide us, the notion of the sovereign state is still vital. The networks that are transnational networks give us some shelter from certain aspects of that sovereign state, and frankly gives us some shelter from the sovereignty of the international community of states operating in ways that citizens are unhappy with. Not every decision of the General Assembly of the United Nations is a decision that citizens want. And so the capacity of citizens to operate across borders facilitated by social platforms and networks is a vital challenge to the state, not to sovereignty, but to the state's power over its human sovereigns.
Thank you, Professor Okediji. And Professor Michael Stein, the Executive Director of the Harvard Law School Project on Disability, had a front row seat to seeing some of these very things that were just being described by Professor Okediji. I wonder if you could offer some wisdom coming from that experience of civil society engaging the drafting of a major UN convention.
Well, it's probably the wrong source for wisdom, and normally I try to avoid speaking after Ruth at all costs, but I agree with so much of what she said. During the drafting of the UN Disability Treaty, we saw the wall come down. So normally when core treaties at the UN are negotiated, it's about the states, the 193 member states, the 2 observers, and there's a wall, and civil society can come in at some point on observer status. In this case, we had a shift, and it's changed the way that the UN operates, at least as far as treaties. Early on, it was not an effort to negotiate a disability treaty, but it was framed as an effort to consider whether there ought to be one. And so the chair, Ambassador Gallegos, said, well, how can we possibly do that without having the stakeholders involved? And using the ECOSOC vehicle by which NGOs are allowed to attend, negotiate, speak from the floor, we had a process over the 5 years where at the first of these 8 ad hoc sessions, 85 individuals from the NGO, DPO as we call them, disabled persons organizations, were present. By the end, we had over 850 represented. And on one level, we can describe it as an erosion of sovereignty in that civil society was able to break down the barriers, enter, interact with states' representatives. But on the other hand, we could also think about it as an education and a cooperation rather than a co-option of state sovereignty. There were many areas where if the states were left to their own devices, they likely would not have gone. So we've had 2,000 plus years of guardianship laws. They exist in every state around the world, and they exist in every state within this country as well. That's probably not where they would have gone. And the revising of legal capacity, of decision-making, of being able to speak and make one's own choices has become, on the one hand, the most empowering device for civil society and has led to law reforms such as mental health laws, in particular in Anglophone post-colonial Africa, and in guardianship regimes all over the world. Probably not what the states were thinking. But by cooperating with civil society, by being educated and working with them, the states were complicit in the idea that this is the direction in which they would move, educated and also empowered, and got a heads up as to what was coming down the road for law reform and so on. At the end of the day, of course, human rights, as any other large transnational scheme, has to be transposed at home. It's about domestic implementation. And so at the end of the day, although we do have this nice set of aspirations, when we go home, we have to see what it means in culturally appropriate, resource appropriate, legally appropriate means. So one can view this device and this dynamic as eroding sovereignty, but one can also view it as increasing sovereignty, educating nations, and creating cooperation.
Wonderful. So it's my turn. And I want to start by thanking Bill Alford. I have to say, when he first said to me, please join me in moderating this panel, and I will say that Bill did the lion's share of the work, and he said, well, there are going to be 2 of us and 9 panelists, and we're going to do this, we're going to discuss all of sovereignty in about an hour. And I thought, how on earth are we going to do this? But as often happens in a Harvard Law School classroom, we actually end up learning much more from each other, as you will all remember from your classes, than from the faculty members. But I'm now going to talk more about networks, or I'm going to moderate the discussion around networks. And we've heard from, as Kuhn started us off saying, the European Union is pooling sovereignty, but they're still sovereign states, overlain by very deliberately created networks of ministers of every kind, of judges, of legislators. And then we heard about structured networks, formal networks of government officials, but then, of course, networks of individual human beings around the world, aided by cyberspace, economic networks of corporations, and, of course, their global supply chains, but also their relationships with one another. We would add civic networks, of course. Indeed, Michael, as you were describing, those are I think of the disability organizations. I think of as a strong civic network, just like the Anti-Mines Coalition and others. And then, of course, criminal networks. So the way I think about this, and the book I wrote on the chessboard and the web, just says we now have to look at the world through bifocals, or through seeing in stereo. We must always still look at the states and look at networks. And my own interest was to talk about how to design these networks much more strategically. But for purposes of today's discussion, we're back in the classroom. And you all came back to be back in the classroom. And one of the things you get to do in the classroom is imagine things that are way out of your ordinary ken. So what I want us to think about is if we were to convene a conference of Westphalia today, although actually it was multiple conferences over a number of years. It was not one conference and one treaty. It was the settlement of Westphalia. But the states came together and to end the 30 Years' War, and they adopted a concept of sovereignty and complete with the idea that the prince of each state determined the religion of each state as a guarantee of peace. It was an effort, just like the UN Charter was later, to adopt a set of rules that they thought would be most likely to lead to peace. So imagine we come together now. We've got plenty of conflict. We have cyber conflict, we have internal conflict, we have governments in conflict with their own citizens, we have economic conflict. Imagine we come together. My opening question is, would we give these networks more formal recognition? Because we're all taught, we all accept that there's this Westphalian system and it's breaking down in various ways, and the networks are evidence of the ways it's breaking down, but we still cling to the system. Would we actually go further and say, okay, yes, they're sovereign states, but they're also, as Professor Naim, you said, human sovereignty. So we're going to give human sovereignty, or we're going to give these networks formal status at international law. Now, Professor Alford is a Socratic teacher, and he called on people. I actually did a lot of that, and given my last name, I remember people talking about students getting slaughtered. I am not going to do that. I'm going to ask for volunteers, but I hope everybody will get a chance to speak. But imagine we really had the chance to formalize what we see happening. How might we do it? How would we think about giving these networks or the participants in them status?
Good. Well, Anne-Marie, I think looking towards the future, such an arrangement, it would have to set in on the complementarity between the states, the nation states, and the network. There is, in my view, no network which can fully operate detached from the basic nation-state level. And we heard that from Ruth and from Monica. I couldn't agree more with them. Ruth gave the example of the European Patent Office, which is indeed not an EU body. But when a patent is granted, the effects of it are depending on national law, including in the 28 member states of the European Union. But as she is well aware of, as a professor of intellectual property law, the European Union precisely is now making an EU patent law to give effect to that European Patent Office. And I take it as an example, her example, to illustrate my point about complementarity between states and networks. The network being the European Union for ease of speech, the states being the member states of the European Union. Now, why is it so that the European Union engaged in making legislation on the EU patent law? For the reason, a term not yet mentioned, of subsidiarity. The Union, the network that is, should act whenever a policy matter transcends the space, the territory of a single state and enters the broader space. We use the term space for the EU, for the network, and the term territory for the nation state. So those are not terms chosen by accident. So once you transcend the scope of the territory of a state, you enter the space. In the space, and I take what Secretary Mabus said, to keep control, you need to participate in the network. There, the sovereignty argument pushes you to participation. A certain country saying, take back control, that is building walls, whereas we should build bridges. Bridges to the neighbors and the neighbors of the neighbors with whom we live in a single space and with whom we can deal with policy matters, whether it be the environment, social standards, patent protection, or what have you, in the single space. So it's a matter of subsidiarity. Now, and I won't be long, the reason why it matters, this complementarity between states and the network, in my example, the Union, the European Union, but I think it also holds true at global level, is a matter of democracy. Professor Naim has rightly said that it should all center around the sovereignty of the human person. That, to me, is the core of what binds us here this afternoon. It's a human person. Now, that means the human person should be center stage at the input and at the output input legitimacy, output legitimacy. Now, it is not easy in the networks to organize input legitimacy through democratic structures. It has lasted till the Lisbon Treaty entered into force at the end of 2009 only, before the Treaty on European Union contains a full Title II on representative and participatory democracy, and the way it works is still relatively distant from the women and the man in the street. It's inevitable. A network is farther remote from the localism of people than the nation state or the region or the city. And it's the obvious, but we may not forget this, because in our enthusiasm for networks, we might forget democracy. And if you take, I see Dieter Grimm in the audience, who has written very sensible things about democracy and democratic anchorage of the network which the European Union is in fact practicing. It is a matter of how to combine the democracy, which is still largely nation-state based for the elections for the national parliaments, how to combine that with an effective participation of these nation-states into the network, which is an inevitable step in the real world vis-à-vis other networks. Positive ones, like Facebook. I would say there's a positive one, although it can be abused, like any good thing can be abused. By way of example, we have to settle on privacy protection, for instance. That's an EU matter. Also, in order to counter terrorism networks, negative networks. So we need a network of governance. But how to combine it with democracy? The key is subsidiarity and complementarity between the participating nation states and the networks. It's certainly not an either-or. It's an and-and.
So Professor An-Naim wanted to join. I'll just say, note that Judge Leonards has he describes the EU, as I believe it is, as a collection of networks. Now, you can reimagine any international organization that way. You can reimagine WIPO as a network of intellectual property ministers. You can imagine NATO as essentially a collection of military networks. That's still very structured. When Monica talks about networks, she's talking about individuals who come together very informally, which makes it the democracy problem even harder. Professor An-Naim.
Yes, as an African, I am not naive about the nature of power, and that it remains, and that when we say we, whenever I hear the term we, I always worry, who is the we? Who is included in the we and who is excluded in the we? And I think that the problem is that if we don't, when I emphasized the notion of the sovereignty of the human person, I meant that in the most radical, totally disorganized fashion. I think it will be a case of death for networks to be organized or co-opted formally. I think their strength is precisely in their decentralization, in their almost like the elusive nature that you cannot grasp. So it is a gamble that we take, but all good things come with risks. So I'm calling for a reimagination of possibilities. Because I think if we just simply go into another cycle, as I said earlier, of sovereignty, maybe not as it was imagined 400 years ago, but not that much different, then we are, I think, limiting our possibilities as human beings living in a globally integrated and risk-infested environment. So in that sense, I believe in taking the risk with the radical sovereignty of the individual person. Now, this does not mean I have no idea about, I am from Sudan, after all. So I know that what states can do and how they can inhibit and limit the ability of their citizens. But the point is that unless we start with that premise, we are not going to imagine new possibilities.
Thank you. So I'm going to call on Secretary Mavis next, and I just want to point out your point about joining or international organizations, increasing your sovereignty, is the argument made by Abram Shays and Antonia Shays, and I have to invoke Abram Shays sitting here today as my mentor and great friend, was exactly that the new sovereignty, and the title of the book is The New Sovereignty, the new sovereignty was the capacity that you got from participation. It's exactly, it's a very strong argument.
I guess my question back to you after listening to these incredibly eloquent, well-reasoned things is, if we had that conference, to what end? Because you've got the networks that are well-defined that you pointed out, the EU, NATO, you can list a lot of different ones. But it would seem to me that if you try to give some sort of formal recognition to these much more individual networks, these much more disorganized networks, these much more ad hoc networks, you in some ways lessen their power. You take away from what has given them strength by giving them some sort of formal recognition. What would be the purpose of having that meeting?
It is always the prerogative of a law professor to answer a question with a question. You wouldn't really expect me to give you an answer. So I'm going to ask Professor Chang for his response to that.
My answer to your initial question about
that's called fighting the hypothetical, but there we go.
Whether it would be desirable for a non-government networks to be given independent status in whatever a forum. Let me give you an example of what happened in the WTO dispute settlement settings. There was a proposal that NGOs, not the government, should be given an independent standing for the WTO dispute settlement, but it was impossible because of the hard black law within the WTO system. Then the second proposal was they must be heard formally by the dispute settlement panel and the appellate body. Then how? And would it be desirable or not? And there is a pro-argument and con-argument. And one side of the WTO members, especially the advanced countries, they like the idea of having the NGOs heard in the dispute settlement proceedings, because it's going to be helpful for the more informed decisions. And for instance, if the NGOs are representing environmental goals or something, why not? Why not excluding them from these dispute settlement proceedings? But the other side, the opposite perspective provides the counter argument, which is normally NGOs are pursuing one single defined goal, whatever that may be. Then it could break the balance between the sovereignties, which advocates some convincing but some contrasting goals or values. So that is one example I wanted to show to you to just let you know that the recognition of NGOs in the sovereignties playing ground might tilt some balance between the sovereignty.
So Michael Stein might want to come in on that, but that's called a volunteering. I'm volunteering you to raise your hand. But you provided an answer to Secretary Mavis's question, which is, if we recognize, let's just stick to civic networks right now, but very quickly, obviously, corporations are going to demand the same thing. If we recognize that they have power and they are getting listened to, and they're getting listened to at the United Nations, they're getting listened to in economic negotiations, then formalizing them answers part of the democracy question, because a network, by definition, is a kind of shadowy thing that people create, and you have no idea who is in them. So if you formalize them and you say, You might say, for instance, networks that have a certain reach and are fully transparent will have the following status. I mean, you can think about how to legitimate them. So there is one possible answer. Yes.
Well, I would say that we have to give good thought about two things. One is that when thinking about formally institutionalizing roles, we need to consider the competencies and the complementary natures of the groups or individuals within those roles. So to just jump out of disability for a moment, one of the interesting things that's going on the international level is GANRI, now the Global Assembly of NHRIs, Human Rights Institutions, formerly the International Coordinating Committee, is giving real strong thought to how to formalize the role of human rights institutions at the treaty body monitoring level. And it raises all kinds of complex questions because these are neither government nor civil society, and they are resourced differently. They have
so explain how they're not civil society for the audience.
They're neither here nor there. They're human rights institutions. They're supposed to hold the government to account. They're supposed to listen to civil society. But at the end of the day, they're supposed to make their own independent and be independent as far as what they feel the role of human rights are and how well or not well they're being implemented within their own countries. And they have different competencies. Some can take complaints, some can write reports, some can do protection and promotion by doing training. It depends on where they are. So one of the issues GANRI is thinking about is how to institutionalize and how to ensure, one, that there's not overlap of competencies, two, that there's not a greater role by those that are greater resourced to doing, and three, what the level is of overlap between what they do in the international level and what they do back home. The second issue that has to be raised whenever thinking about formalizing roles of non-governmental organizations is the issue of elitism.
Yes.
Which is there are certain organizations that have the money, power, influence to appear on a regular basis in New York and Geneva, and many of them do fabulous work. But when it's the same small number of bodies who appear on a regular basis, and especially the same, usually, number of individuals who are prominent in appearing on the same basis, you need to ask scrupulously and difficultly, are they representing the broader scope of civil society? Or are they representing a particular view? And are we trotting over or ignoring other views as well?
So that's exactly why you might say the Treaty of Westphalia and certainly the UN Charter enshrine sovereignty to ensure that the least state had the same vote as the greater state. So again, why would we formalize networks now? Because without that, some participants in networks and thus some networks have much more power than others. And could you actually find a way to rectify that? Monica. I just have to say, I taught three people on this panel, but Ms. Bickert, please.
Yes, Professor Slaughter. I think it depends on how we measure power and impact. Because some of the networks are going to form, if people have the ability to communicate with one another, which they often do online now, networks are going to form where they are needed. And when you have situations, I think about, through the Facebook lens, in the wake of a crisis. The Barcelona attacks happened. We have something on Facebook called our Community Help Center, and people went into the Community Help Center and listed, I need a place to go, I need money, I need a way to reach and people helped them. And we had, I think, more than 8,000 listings and responses in the wake of the Barcelona attack. So that network that sprung up immediately, small, very flexible and dynamic, was incredibly impactful for the people who needed it. And this is, I think, the strength of networks, is that you don't have to have power in the traditional sense. You don't have to have a seat at the UN to have tremendous impact in people's lives. To look at a sort of a different type of network that I end up seeing in the course of my job at Facebook, we are often working with industry, across industry, and with civil society groups, academics, other stakeholders, and governments in these networks that have people coming from very different places and perspectives to try to accomplish a common objective. And the example I'll give you is counterterrorism. We're sort of a part of different networks in that space, but one that has been interesting to watch evolve was what we do across industry and civil society specifically. A couple years ago, we realized that it would be easier for us to learn about trends in what terrorists are trying to do to use social media and talk about developments of technology, what's working and what's not working to try to respond to this threat. And so we just naturally reached out to the other companies in our industry, to Google, to Twitter, and to some of the academics that we know study this and some of the civil society groups that focus on this. And we started meeting informally. Again, barriers to entry were low. We were able to be really nimble because this was a very informal network. We got a lot done. We ended up getting some pressure from governments, which I understand. They wanted more insight into how that network was working. So we ended up formalizing that network. It's now called the Global Internet Forum to Counter Terrorism, GIFCT. It rolls off the tongue. But GIFCT, we now have more than 50 companies participating. We have a lot of civil society organizations and academics. And at the UN General Assembly, there was a side event on countering terrorism, and GIFCT had a seat up there with Theresa May and Emmanuel Macron. So it was interesting to see this sort of evolution of this network to one that was interacting at the UN. Now, would it make sense to have networks like that have this sort of permanent presence? I don't think so. These networks are going to be, part of their strength is that they are so dynamic and they do fill the gaps where we need them.
Yes, please, Ruth.
Thank you. I just wanted to add something to what Monica just said, because I think there is something underpinning to the extent social media and technology is responsible for spontaneous networks and the capacity to aggregate sovereignty, human sovereignty. There's something really critical then to what that tells us about the Westphalian model. And that is the kinds of underlying values that give rise to those networks are really vital, because the difference between a bad network and a good network is about the values. You know, what were they? And this is Kuhn's point about if it's not about democracy and Abdullahi's point about the human person, if we don't combine those 2 points, these networks are problematic. They are just as problematic as the Westphalian state. And I say that also because I'm an IP scholar, so my students who are here will know that two things then become critical. If networks are going to be as powerful in the digital age as we expect them to be, they're going to be as effective, nimble, inclusive, then the kinds of rights that we recognize as the new civil rights matter. Does everyone have access to the internet? I'm from Sub-Saharan, I was born in Sub-Saharan Africa, raised in New York, and I can tell you that my life is very different. And it is the grace of God that I am where I am, but there are millions who cannot participate in networks today because they don't have access, right? Think about what we're doing in the US with net neutrality. If the networks have the power to decide who speaks and who doesn't speak, who receives information and who doesn't receive information, then the networks themselves become, in essence, an expression of the Westphalian state in its weakest form. So I think part of what this discussion does is it forces us to disaggregate what this nation state was meant to do. Because whether it's here to stay or it's being disrupted, technology is meant to disrupt, right? All of our new technologies are disruptive for a reason. But what endears is the values that make those networks or those states enduring. And unless we resolve those fundamental issues in a digital age, we are not going to see networks perform the kinds of roles that exceed what states were able to do. They may come and go here and there. They may have some impact, sometimes big, sometimes small, but they could do so much more.
So I'm going to turn to Professor Chen, and then Elaine, if you want to close it out, and we'll turn to questions. But note the tension there, that you want to keep them informal because that's their power, because they're swift and nimble and adaptive. But the more you do that, the more you have the elitism, the power imbalance, and the formalization is necessary both to apply standards, but also to give people an equal shot at being part of them. Professor Chen, yes.
Thank you.
The point about equipment, yes.
Thank you all. I've been really traveling from very, very far. That is from Taiwan, taking about 16 hours or so. I just want to address to you several issues. I hope I can afford to do that within, say, 5 minutes or 6 minutes. That is, I'm asking myself the question that, what sovereign states, what's state for? I mean, even as dating back from Westphalia, I mean, those era until today. To answer the question, I think this is a big question, huge question. I think it's very difficult, but I can only perhaps cite the recent declaration of rule of law by the General Assembly, 2012, I remember, in which it says that the UN, the three pillars of the United Nations being peace, human rights, and sustainable development. In the declaration also says that without rule of law, none of this can be viable or could be established. And that really, I think, applies with equal force to the reason why we need a sovereign state. The reason why a state should have the sovereignty. Sovereignty means supreme authorities, which means that nobody else can interfere with the country's sovereignty. But having said this, I also like the idea just raised by one of the panelists, or all of us will agree that is state sovereignty is equally important to, say, human sovereignty. Again, citing what I just asked my question, which one is more important? If you can just have one, that is human sovereignty important than state sovereignty, or state sovereignty important than human sovereignty? I would certainly say that only wish we can have both. If we cannot have both, I would say human sovereignty is more important, perhaps. Then, if I may just share with you a question which has been really haunting me for the last 30, if not 40, 50 years, that is the problems between Taiwan and mainland China. And you do know where's Taiwan and what Taiwan means, and also where is mainland China and what does mainland China means. These two places all says that we are the China, and the other part being part of us, and so on and so on. And of course, things have changed in Taiwan, and also things have changed in mainland China as well. What I really want to say is that before 1971, the General Assembly Resolution 2758 says that Beijing government in mainland should replace Taipei government in Taiwan as the representative of China. Ever since then, of course, Taiwan has becoming sort of an orphan in the international community. As such, Taiwan, even though being a sovereign state with all the sort of requirement by, if not Westphalia, but at least the 1930s Montevideo Convention, etc., etc. But on the other hand, Taiwan has been cut away from of the international community in the sense that Taiwan cannot, for example, ratify any multilateral treaties, even though Taiwan has made extra effort to incorporate, for example, 5 of the Human Rights Convention, namely the 2 international 1966 Covenant on the Political Civil Rights and the Socio-Economic Political Rights, and also the non-discrimination against women, and also protection of, and so on, so on, so on.
Professor Chen, I'm going to exercise the law professor's right
of
just asking you to finish a little more quickly, because I do want to get to questions. So if you can just make the point on sovereignty particularly, that would be wonderful.
My point is that when Taiwan was representing the entire China in United Nations, Taiwan actually excluded the Beijing government from exercising the sort of a sovereignty right, insofar as in those era, I will consider 800 million people in mainland is not being admitted under the United Nations. But ever since 1971, ever since Beijing being the legal representative of United Nations, and Taiwan, the 21 million people have been excluded from being sort of part of the United Nations. My question to you and all, and also the Harvard Law School, this is a typical case, or a atypical case. What do we do to make sure that all people, especially those people who work very hard for sort of a human sovereignty, can be entitled to sort of their voice be heard through, for example, the network. We talk about Facebook or the others. Question, of course, Facebook is, I understand, it's not working, for example, in mainland China. It doesn't really mean mainland China is not doing its job. I think mainland Chinese is doing its good job. I think certainly we should do the very best. This is something I also like to share with all the audience here, talk about what really does human sort of sovereignty means. I think we should really come down to a good example. This is the example I want to cite for your reference. Thank you.
Thank you. Thank you. So, Elena, in that was an example of on-off sovereignty. That if one part of the nation is recognized, the other is not. But if you can just close us off on the question of networks, and prepare your questions, please.
Big responsibility, but I'll do my best. I just wanted to talk a little bit about how to train lawyers in the global South in this idea of networks, because I'm sitting here and I'm listening to these really interesting ideas. But when you think about the way law is taught around the world, and I would include many places, it's still state-centered. It is still about local laws. It is still about knowledge that is very traditional. I get the feeling as a law professor all the time that I'm teaching things that are actually not relevant for students at all. And I've thought about it teaching administrative law, property, I mean, you name it. And so I was wondering also if we are invested in the idea of strategically thinking about networks, there has to be a counterpart in legal education, and there has to be a way of, thinking about legal education differently across networks in a way that is much more open, less sovereign-centered. So that would be my...
Thank you. Thank you. And that's, again, the question. They're informal, so it's hard to teach about them. So I'm going to turn to the audience. I would please direct your question at one member of the panel, because if we have one question and 9 answers, we will have exactly one question. So please, if you could, direct your question.